information valuable. So with that, I'm going to pass it on over to Daniel for him to go ahead and get started. Welcome, Daniel, and welcome to everyone that's joining us this evening.
Thank you so much, Nikki. My name is Daniel Alper. I'm a staff attorney at HERA, Housing and Economic Rights Advocates, and this evening I'll be presenting an overview of homeowner rights and options with regard to home preservation in the age of COVID-19. So let's begin. I'd like to start with just a brief overview of what expenses can become a risk of foreclosure. So of course, your monthly mortgage. As we know, in the age of COVID-19, a lot of folks are struggling to make their monthly mortgage payment. And if you do fall behind on your mortgage, that can become a risk of foreclosure. There's a timeline that mortgage servicers have to adhere to in moving forward with a foreclosure, and I'll talk about that a little bit more later. That timeline is about 7 months and 3 weeks from the start of the default for a mortgage. For property taxes, however, which can also be a risk of foreclosure if you fall behind on your property taxes, that may also put you at risk of foreclosure. The timeline for foreclosure due to defaulted property taxes is much longer, though. The amount of time that it takes for a foreclosure sale to go through after you default on property taxes is 5 years. So you have 5 years from the time when you default before a foreclosure by the county is going to happen when you default on your property taxes. So there's a much longer timeline there. Homeowners insurance, it can also put you at the risk of default if you fall behind on your homeowners insurance payments, especially if they're paid through an escrow account. So if you have an escrow account with your mortgage servicer and you fall behind and your escrow account has a deficiency, and that might increase your mortgage payment, which could put you at the risk of foreclosure. So specifically, the escrow account can itself become a risk of foreclosure, if, especially if there is a deficiency. Homeowners association and condo fees, those are separate fees that you pay to your homeowners association if you live in one. And the homeowners association, if you fall behind on your monthly dues to the homeowners association, that could also put you at risk of foreclosure. There's also a very strict timeline and set of procedures that a homeowners association must adhere to if it elects to move forward with the foreclosure process. And that's one of the many services that HERA provides is we can provide homeowners with advice about how to handle falling behind on their homeowners association fees, because as I mentioned, that can also be a risk of foreclosure. In addition, if you are having maintenance or repairs done on your property, that could also potentially be a risk of foreclosure. If you don't pay the contractor might record a mechanics lien on the property, and that could be executed through a judicial foreclosure. So that would have to go through the court system. Most foreclosures in California are non-judicial foreclosures, which means that they are conducted through a notice and recording procedure, which I'll explain in a little bit. But so if you were to have home maintenance and repairs and did not pay the contractor and a mechanics lien was recorded, the foreclosure process that would ensue would be judicial. So that would be through the court. Another risk of foreclosure that we see with regard to home improvements may arise if your home improvements are PACE financed. PACE is Property Assessed Clean Energy. It's a financing program for energy efficient home improvements, which imposes a first priority lien on the property, which is payable through assessments on your property taxes. So if you obtain PACE financing for home improvements, that may also put you at the risk of foreclosure, either if you fall behind on making the payments through your property taxes, the PACE company could foreclose, and that would also be a judicial foreclosure. And also, if you fall behind on your property taxes because the PACE assessments are repaid through your property taxes, that could also create the risk of foreclosure. And we have seen those PACE assessments cause property taxes to increase significantly. So that's something to be aware of if you're thinking about getting some home improvements. That might be something that you check in with Hare about, and we can discuss your options for how you might finance those home improvements. So let's talk a little bit more about what the foreclosure timeline is when a mortgage servicer or lender moves forward with foreclosure. So importantly, a mortgage lender or servicer can foreclose without filing a lawsuit. So it's a non-judicial foreclosure. And again, the vast majority of foreclosures which take place in the state of California are non-judicial foreclosures. So the timeline starts with the homeowner not missing a payment, so default. And after you miss a mortgage payment, when you fall into default, the servicer has to wait 120 days before it can record a notice of default. That's the first notice that is recorded in this process. During that 120-day period, the mortgage servicer is supposed to contact the borrower and explore options for loss mitigation, meaning ways to avoid the foreclosure. And when the servicer does, after that 120-day waiting period, after the default, when the mortgage lender or servicer does record the notice of default, it must declare in the notice of default that it did do its due diligence to contact the borrower and make the effort to explore those loss mitigation options. So again, if you receive a notice of default or one is recorded against your property, that would be something that you might want to contact Hera about, because we can certainly offer advice and assistance in that regard. So after the notice of default is recorded, there's a 3-month period during which the servicer must wait, and you have an opportunity then to resolve the matter, to try to negotiate some sort of workout option. I'll discuss what those workout options might look like in just a few minutes. But if a resolution is not arrived at, if a workout is not negotiated, then 3 months after the notice of default is recorded, a notice of trustee sale can be recorded against the property, and it must be also posted on the property. And so the notice of trustee sale, it looks similar to the notice of default, but it's the next step in the process, and it's alerting you that 20 days after the notice of trustee sale is recorded, that the mortgage servicer can hold an auction and sell the property in foreclosure. So after the foreclosure takes place, if the foreclosure does go through, then essentially after it's all complete, the homeowner, if you don't leave voluntarily, then essentially at that point you become essentially a tenant to the new owner. And so the owner would have to seek then to evict you through the unlawful detainer process. Some new owners might want to try to get you to leave, try to get the homeowner, pardon me, to leave without the eviction process. And so they might offer cash for keys. So sometimes there will be an offer for a few $1,000s to essentially move, and they'll exchange that for the keys to the property. And that might be helpful if funds are needed in order to move forward with that moving process. Also, sometimes courts, if it's an emergency situation, courts will sometimes grant an extension of time to the previous homeowner who was foreclosed upon, so that they have additional time to move out of the property. So there may be some options for dealing with the moving process after a foreclosure is complete. In addition, if there are surplus funds that are remaining after the foreclosure sale, if the sale proceeds exceed the amount that was required to repay the mortgage loan, then you have a right to collect those surplus funds. And there's a process to do that. It involves contacting the foreclosure trustee and making a claim, and that's also something else that Hera can provide advice and assistance about. So what are your options for keeping your home when you fall behind? So one option might be a refinance. That means taking out a whole new loan. You take out a new loan, you pay off the old loan, and now you have a whole new mortgage loan. That's not going to be available if you're already in default, because when you fall into default and a notice of default is recorded against the property, that puts the whole world on notice that you've fallen behind. And so that's going to make it extremely difficult to obtain a new loan. So refinance, again, has minimal availability and likely not available if you've already fallen behind. Reinstatement is another option. So this means paying off all of the arrears as well as any additional foreclosure fees, attorney fees for the foreclosure. And that can be done up until 5 days before the scheduled foreclosure sale. In order to do this, you need to obtain a reinstatement quote from the mortgage servicer to identify exactly how much it is required to reinstate the mortgage loan. A complete payoff. So a reinstatement is just paying the past due amount and any additional foreclosure fees, attorney fees, and things like that. A complete payoff, meaning paying off the entire mortgage loan, can be done at any point up until the foreclosure sale. You could also negotiate a repayment plan. Typically, that involves adding an amount to the monthly mortgage payment and repaying the amount that's past due over a period of time, spread out over however long it takes to repay the defaulted amount. So also you might get a forbearance for a temporary hardship, and that is one of the main options that is available through the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act, which I'll talk about a little bit later. And so a forbearance is just a temporary pause on payments. It doesn't mean that the payments are forgiven or not due. It just means that they're not due right now. They will become due later. And there may also be special forbearance plans available for folks who are unemployed. You may also seek a loan modification. A loan modification means that all of the arrears are recapitalized into the principal balance, and the loan is recast over a new term of years, typically at a lower interest rate, ideally. And so the ideal outcome for a loan modification would be that your monthly payment would be reduced so that the monthly mortgage payment would be more affordable after the loan modification is complete. It typically requires a request for assistance application to be filed with the mortgage servicer. Mortgage servicers typically have these available on their website. You can also request one by making a phone call to them. And so in order for the mortgage servicer to consider the application, it needs to be a complete application. So it's important to identify what the required documentation is before you submit the application. And again, modification applications are something that Hera can certainly offer assistance with. Litigation victories may also help you to keep your home if a homeowner were to file a lawsuit against the mortgage servicer and win. If the servicer had wrongfully initiated foreclosure or something like that, then you might be able to secure a victory against the mortgage servicer, which may afford monetary relief that would help you to retain your home and repay whatever the arrears are. And you also might consider bankruptcy. We at Hera, we usually say that's the very last option because of the kind of harm that it can do to your credit report. I'll talk a little bit more about bankruptcy later. bankruptcy also might be an option, although there are some limitations to the relief that bankruptcy can afford. So let's talk a little bit about the CARES Act. So again, the CARES Act is the Coronavirus Aid, Relief, and Economic Security Act passed by the federal government, and it protects homeowners with federally or government-sponsored enterprise-backed mortgages. So that's about 70% of all mortgages. That includes mortgages that are administered by the Department of Veterans Affairs, the Federal Housing Administration, and the USDA, United States Department of Agriculture. That's for more rural housing loans. Also, loans that are backed by government-sponsored enterprises, Fannie Mae or Freddie Mac. So there is a moratorium on foreclosures under the CARES Act. That moratorium on foreclosures lasts until February 28th of this year for USDA, FHA, and VA loans. The moratorium for government-sponsored enterprise loans, Fannie Mae and Freddie Mac, the moratorium on foreclosures owned by Fannie Mae and Freddie Mac expires on January 31st this year. Those dates have changed. These are the most recent updates that we have. These may potentially change, but these are the moratorium deadlines as we have them currently. So what does the forbearance plan under the CARES Act provide for? So the forbearance that you can request under the CARES Act is up to 180 days. So you can request a forbearance of up to 6 months due to financial hardship that is directly or indirectly caused by the COVID-19 emergency. The way that you request this is simply by asking the mortgage servicer. So the mortgage servicer is not supposed to ask you for proof of the hardship. The homeowner should be able to attest to the hardship caused by COVID-19 and obtain the forbearance. That would be if the loan does fall under the CARES Act, and I'll discuss how you can find out whether your loan is protected under the CARES Act in just a minute. So again, a few things to keep in mind. With a forbearance plan, your payments are not forgiven. So it's not that you don't have to pay them, it's just that they're put on pause. The loan will continue to accrue interest. You will be required to make up any missed or reduced payments, and there will be different repayment options at the end of the forbearance based on the type of loan that you have. After the initial 6 months of forbearance, you have the right to ask an extension for up to another 180 days. So even though the initial forbearance period is 6 months, the total amount of forbearance that you can request under the CARES Act is for a whole year, 360 days. So to apply, again, you must contact your mortgage servicer and let them know about your hardship and ask them for the forbearance. So there are some deadlines to request the COVID-19 forbearance. So homeowners with FHA insured loans, VA loans, and USDA loans have until February 28th of this year, 2021, to request the COVID-19 forbearance. Again, that may be subject to change. That's the most recent information that we have now. Homeowners with multifamily mortgages. This is different than 1 to 4 unit properties. So multifamily mortgages, that means more than 4 units. So homeowners with multifamily mortgages, more than 4 units, can request a forbearance under the CARES Act until March 31st. Although keep in mind that the rules for requesting a COVID-19 forbearance for a multifamily mortgage are different. Unlike a residential, a single family 1 to 4 unit property where the mortgage servicer cannot ask for documentation of the hardship, for a multifamily mortgage, the mortgage servicer can ask for documentation of the COVID-19 related hardship. And also the forbearance period is much shorter. So again, the rules for multifamily mortgages are different. The discussion this evening is mostly centered around 1 to 4 unit properties. Keep in mind there is no updated guidance as to the deadline to request COVID-19 forbearances for homeowners with single family mortgage loans. So what our advice would be is that if you have a loan that is owned by Fannie Mae or Freddie Mac and are considering a forbearance, it may be in your best interest to ask for one sooner rather than later, because we're not sure exactly when the deadline to request one will be. So if you're not sure whether your loan is protected by the CARES Act, there are some ways that you can look it up. So you could go to the Fannie Mae or Freddie Mac website. The links are here on the slide, and these slides will also be distributed, as far as I'm aware. And if your loan is from the VA or FHA, usually that will be indicated in the deed of trust. For VA loans, there will be a reference to the Department of Veterans Affairs. FHA loans, by contrast, usually have an FHA number. USDA loans may have a guarantee attached to the loan, or there may be some indication in the HUD closing statement that it is in fact owned by the USDA. You could also send a formal request for information to the mortgage servicer, and a request for information is under RESPA, the Real Estate Settlement Procedures Act, and that's also something that HERA could provide assistance with if needed. Okay, so if you do obtain a forbearance, during the forbearance, there are some things to keep in mind and keep track of so that everything goes smoothly. So unfortunately, mortgage servicers don't, like all people, don't do everything perfectly. They do make mistakes. There might be errors, so it's important for borrowers who enter into forbearance to be mindful of that. So check your mortgage statement for errors. For example, on the mortgage statement, there may be an indication that the loan is in default, even though you asked for forbearance. It's not supposed to be indicated as such on the mortgage statement. It's also not supposed to be reported as late to credit reporting agencies. So if you see on your mortgage statement that the loan is listed as in default, then and you have asked for and been granted a forbearance, then that would be a situation where you would want to contact the mortgage servicer and confirm that in fact you are in forbearance and alert them to that error. Also, if you have automatic payments, it is important to stop them. Even though you've asked for a forbearance and been granted one, the mortgage servicer, if you have automatic payments, may continue accepting and applying those payments. So if you have automatic payments, it's important to stop them. Also, as I mentioned, under the CARES Act, when you obtain a CARES Act forbearance, the mortgage should be reported as current to credit reporting agencies. So it's a good idea to check your credit report regularly, because if you were current before the forbearance, again, you should be reported as current during the forbearance. So you can also obtain a free credit report from annualcreditreport.com. And so again, keeping tabs on your credit report is a good idea while you're in forbearance. When your mortgage loan comes out of forbearance, it's important to resume the payments. And also, if your income resumes at any point and you're able to make the payments again, then it would be a good idea to start making the payments if you can afford them, because again, as I mentioned previously, the payments are not forgiven when you have a forbearance. They're simply made due later. The payments are simply put on pause. So if you can make the payments, it's a good idea to resume them so that you don't continue building up arrears that will eventually have to repay later, because that amount that is due at a later date may be difficult to afford. Although again, in most instances, you cannot be required to pay the entire forborne amount right when the loan comes out of forbearance. You still, if you can, it's a good idea to resume making those payments once you're financially able to do so. If you need more time on forbearance, if you're continuing to experience a COVID-19 related hardship, then you should request an extension of the forbearance. We certainly don't advise you to spend your entire life savings on your mortgage if you're not going to be able to put food on the table. So if you are continuing to experience a hardship, it's a good idea to ask for that extension. In order to plan ahead for making those payments once the loan comes out of forbearance, we do advise that you do what you can to save and put funds aside for when that loan comes out of forbearance so that you can afford those payments once the loan becomes active again. Some other things to keep in mind while your mortgage is in forbearance: if the taxes and or insurance are paid for through an escrow account on your mortgage, confirm that your mortgage service is continuing to pay them. We would assume that they would, but you would want to confirm that because you certainly wouldn't want to fall behind on your property taxes, for example. That, again, as I mentioned previously, would create another risk of foreclosure. And if the mortgage servicer does indeed confirm that it continues to make the property tax payments while the loan is in forbearance, keep in mind you may have an escrow shortage that you may need to repay at the end of the forbearance. An escrow shortage meaning when the mortgage servicer pays for your property taxes through your escrow account, and then, as we discussed previously, that there may be a shortage in that escrow account after the mortgage servicer makes that payment, and that escrow shortage can result in an increased monthly mortgage payment. So that's something to keep in mind that may occur if your mortgage servicer pays for your property taxes through the escrow account. If you don't have an escrow account, then you should continue to pay your property taxes, your homeowners association fees, and other home-related expenses if possible, because, again, those expenses may, if you default on them, may create the risk of foreclosure. So you wouldn't want that to happen. So again, if your mortgage servicer does not pay for the property taxes and HOA fees through the escrow account, that would be something that you would want to continue to cover as long as you are able to do so. And again, if you're concerned that you might not be able to make those payments, HERA is here to offer advice and assistance. Okay, so should you request a forbearance? We've talked all about the ins and outs of what it means to have one, but should you ask for one to begin with? So again, what's important to keep in mind here is that the payments that are skipped during the forbearance will become due sooner or later. So if you can afford to continue making your payments, it's a good idea to keep making them. However, we wouldn't want you to spend your entire life savings, all of your savings on your mortgage if you're not going to be able to cover other basic needs like putting food on the table. So unless you're absolutely certain when your income will resume and can budget for that by continuing to pay your mortgage and budget for other expenses, if you're concerned that you might not be able to continue covering your mortgage and other expenses, then you might want to request a forbearance. And again, you can always contact HERA to see whether or not that makes sense. And we can give you advice about that. If you cannot afford to continue paying your mortgage, then requesting a forbearance is better than falling into default, because again, when you default, that can lead to extra fees, attorney fees, and foreclosure fees that are imposed by the mortgage servicer that they're allowed to impose on the borrower. In addition, if you fall into default, that can potentially lead to the risk of foreclosure of your home unless a workout agreement is negotiated with the servicer. And also, falling into default can significantly harm your credit. So for all those reasons, if you cannot afford to continue paying your mortgage, it is a good idea to ask for a forbearance. And ideally, you should contact your mortgage servicer and see what your options are before you miss a payment, so that you're not reported as in default, because again, that can harm your credit and all of those other things. If you are denied a forbearance, then you may be able to submit a complaint to the Consumer Financial Protection Bureau using its complaint portal. It's fairly straightforward. Again, that's something HERA could help with. And you And so you should check with your mortgage servicer about all available options, such as loan modification as well when you're having that initial discussion with them. You can either contact Tara or a HUD certified mortgage counselor in order to discuss whether the mortgage servicer has wrongfully denied your forbearance and what your options are for addressing that. When you file a complaint with the Consumer Financial Protection Bureau, what their role usually is at this point is that they will contact the mortgage servicer and ask them to issue a response. The Consumer Financial Protection Bureau does not always investigate individual complaints. However, that may change with the new administration. But generally, what a Consumer Financial Protection Bureau complaint will accomplish is it will bring the mortgage servicer to the table and require them to issue a response to your complaint. All right, and at the bottom of this slide, there's a link to information about obtaining HUD certified mortgage counselors. Okay, so if your mortgage is not covered by the CARES Act, then you will need to contact your mortgage servicer to see what options are available. Some lenders and servicers that are not covered by the CARES Act are still providing voluntary relief, that even though they're not required by law to provide it, they are voluntarily providing COVID-19 related relief, forbearances, and the like to borrowers. Regular loan modifications should also still be available. So even if your loan is not protected by the CARES Act, you may still be able to request a modification. Again, as I mentioned previously, in order to request a modification, you will need to submit a complete application to the mortgage servicer, and usually they'll have that on their website with a list of the required documentation. Repayment plans and regular forbearances should also be available. So loss mitigation options that would have been available before the COVID-19 pandemic hit, all of those loss mitigation options that were available previously should continue to be available. Keep in mind, when you contact your mortgage servicer, if you call them, their call centers are very overwhelmed. They are inundated by phone calls. I have spent hours waiting on hold to try to get in touch with mortgage servicers. So if you do have to contact your mortgage servicer, be ready for a potentially long hold. And if you can, see if you can either contact the mortgage servicer through their website. Sometimes they'll have some sort of online communication portal, especially if you have an online account with your mortgage servicer where you make your monthly mortgage payments through your online account. And some mortgage servicers, you can even request forbearance and other and things like that directly on the website. So it might be a good idea to check what options are available on the website before you make a call to the servicer, because like I mentioned, their call centers are very overwhelmed right now, and you can spend a long time waiting on the phone to get in touch with them. So what happens at the end of the forbearance? I know this is the moment we have all been waiting for. So what happens to the payments after forbearance largely depends on who owns or guarantees your loan. So the Federal Housing Administration, HUD, Fannie Mae, and Freddie Mac all allow placement of the past due amount into a partial claim lien that gets paid when the loan is refinanced. So essentially you take the forborne amount and it goes to the end of the loan, and it's not due until the property is sold or refinanced. That option is available depending on eligibility, and I'll talk about the eligibility requirements in just a minute. If you have a loan from the Department of Veteran Affairs, there are opportunities to apply for loan modification or repayment plans. The USDA for Rural Housing Services is offering term extensions as well as repayment plans. And for non-federally backed loans, you would need to check with your lender or mortgage servicer to see what options are available after forbearance. Some of these options, like the deferral, the partial claim lien, those options may also be available with lenders that are not covered by the CARES Act, but you would need to reach out to the lender or servicer and identify what those options are in order to assess what your options may be. Okay, so if your mortgage loan is owned by Fannie Mae or Freddie Mac, here are your options after forbearance. The first option is reinstatement. So they may ask you, can you afford to pay the forborne amount in full? And if you can, they will want you to do that. And so if you aren't able to do that, then they'll check and see if you can pay the forborne amount in installments, if you can have a repayment plan. And this whole process, what they call it, is a waterfall. So they have to go sequentially through these options. So they'll start with asking if you can reinstate, then they'll check in on the repayment plan, and so on and so forth. So again, a repayment plan as opposed to a reinstatement would be paying the forborne amount in full. Repayment plan would be paying the forborne amount in installments, which go on top of the regular monthly mortgage payment. If neither of those options work, then you may be eligible for a deferral. So a deferral means that the principal and interest arrearages and any escrow advances will be deferred as a lump sum to the end of the loan. Again, that is due when the home is sold or refinanced. And there are some further requirements for that, and I'll get into those in the next slide. Lastly, for Fannie Mae and Freddie Mac, if you're not eligible for the deferral, then you may be eligible for what's called a flex modification with reduced eligibility requirements. This is a type of loan modification which again takes the arrearage and capitalizes it so that the loan is recast over a new term of years. And it has less stringent requirements than a traditional loan modification. And I'll talk about what those requirements are in just a bit. Okay, so in order to be eligible for the deferral, if your loan is owned by Fannie Mae or Freddie Mac, the loan must have been current or less than 2 months delinquent as of March 1st, 2020, which is the date of the national COVID-19 emergency. So that means that the loan must have been paid at least through January 1st, and the loan must be equal to or greater than, so at least 1 month delinquent, but no more than 12 months delinquent as of the date of the evaluation for the deferral. If the homeowner was more than 2 months delinquent as of the date of the national emergency, then you would need to obtain approval from Fannie Mae or Freddie Mac in order to be able to obtain this deferral option. There are a few more requirements in order to obtain the deferral. You must be on a COVID-19 forbearance plan, which means that you must have experienced a hardship resulting from COVID-19, and that hardship must be resolved such that you are able to continue making the monthly contractual payment and be unable to reinstate the mortgage. So again, the servicer will ask whether you're able to reinstate or enter into a repayment plan, and the servicer must determine that you are not able to in order for you to be eligible for this deferral. So if you are not eligible for the deferral option, then you may be eligible for a flex modification with reduced eligibility. So what that means is that the monthly payments are reduced by capitalizing the arrears into the principal balance and extending the loan term. So recasting the loan over a new term of years. This option is available to homeowners that can't afford to resume what their prior payments were, meaning that the contractual payment that was in place before the forbearance is no longer affordable. Or if you're ineligible for the COVID-19 payment deferral, then you may be eligible for this flex modification option. So here are the requirements for a flex mod. The property must be owner occupied, and it must be a conventional first mortgage. The borrower must not be capable of maintaining the current contractual payment, or the loan is greater than 12 months delinquent at the date of the evaluation. However, the loan must have been current or less than 2 months delinquent as of March 1st, 2020, and must be greater than 90 days delinquent, at equal to or greater than at least 90 days delinquent as of the date of the evaluation. For the flex modification option, a trial payment plan is required, as with most modifications. So with most modifications, you will have to do what's called a trial payment plan, which means there's a trial period during which you make the payments that are what the payments will be under the modified mortgage agreement. Essentially, this is so that the mortgage servicer can determine that you can in fact afford to make what that modified monthly payment will be after the loan is modified. And so there is a trial payment plan required for this flex mod option. Important things to keep in mind about post-forbearance procedures. So the servicer, if the loan is owned by Fannie Mae or Freddie Mac, must initiate the review for a post-forbearance workout within 30 days of the end of the forbearance. So if you don't hear from your mortgage servicer, it's definitely a good idea to get in touch with them and discuss what your options are. Again, these options are evaluated through this waterfall process. So the servicer must first evaluate for reinstatement, then the repayment plan, then the deferral, and so on. Okay, so FHA loans. So if you have an FHA loan, here are the post-forbearance options. You may be able to get a standalone partial claim that's similar to the deferral for Fannie Mae and Freddie Mac loans, and I'll talk about that a little bit later. So there's the owner-occupant loan modification. You could get a combination partial claim and loan modification, so that's sort of a hybrid option. You may also be able to obtain a home affordable modification program modification, so a HAMP modification. And again, these options are evaluated also in the waterfall process. So the servicer has to start with reinstatement and then repayment plan and then the partial claim and so on. Okay, so a partial claim. So again, the partial claim is similar to the deferral for GSE loans. And so the partial claim defers the repayment of the principal and interest arrears through an interest-free subordinate lien that's not due until the first mortgage is paid off. And so the deferral, the deferred amount, will include principal, interest, taxes, and insurance, as well as any escrow shortage. Late charges, fees, and penalties must all be waived. Keep in mind that the partial claim must not exceed the maximum statutory value of a partial claim for FHA loans. That maximum statutory value is 30% of the principal balance at the time when the forbearance is initiated or the default takes place. So for example, if you, let's say in 2010, you fell behind and you obtained a partial claim for $30,000. And so you would then have a partial claim for $30,000. So you'd have a subordinate lien for $30,000 at the end of the loan. If at the time of the default, back in 2010, the principal balance was $200,000, then the amount that you would have remaining would be an additional $30,000 to add as a partial claim, because you would have used up half of that statutory maximum value of a partial claim for an FHA loan. So again, if you have a prior partial claim on the end of your loan, that unpaid principal balance, which is going to serve as the benchmark for what's going to be the maximum statutory value, 30% of that unpaid principal balance, that unpaid principal balance is determined as of the date of the original default if you had a previous partial claim. So it's not going to, the 30% of the principal balance, that principal balance is not going to be based on the most recent default. It's going to be based on the time when you originally defaulted and obtained that first partial claim on the loan. All right, so in order to be eligible for an FHA partial claim, you must have been current or less than 30 days past due as of March 1st. so paid through February as of March 1st. The borrower must indicate the ability to resume making on-time payments. The property must be owner occupied. And again, the partial claim must not exceed the 30% maximum statutory value of the partial claim allowed for an FHA insured mortgage. Keep in mind also that you are only eligible for one permanent COVID-19 home retention option. You can't get a partial claim and a modification, for example. There may be an option to do the hybrid partial claim and modification, but you can't do more than one. You can only get one, so that's something to keep in mind. If you're not eligible for the FHA deferral option, the partial standalone claim, then you may be eligible for the COVID-19 owner-occupied loan modification. In this option, all of the late charges, fees, and penalties must also be waived. As is typical for a modification, the arrearages for unpaid interest, as well as advances for escrowed items, will be capitalized into the principal balance. Keep in mind also that for this option, if you had an adjustable rate mortgage, meaning that the interest rate adjusts over time, that modified mortgage is going to be modified to a fixed rate mortgage. That fixed interest rate must be no greater than the market rate identified by HUD. And the new term for the modified mortgage is 360 months. And it can be less if requested by the borrower, but otherwise the new term for the modified mortgage is going to be 360 months. All right, what are the requirements to be eligible for a COVID-19 owner-occupied loan modification? So you must be current or less than 30 days past due as of March 1st, so paid through February 1st. The borrower must indicate the ability to make the modified mortgage payment. The property must be owner-occupied. And for this option, there's no application or trial plan period that is required. So as I mentioned before, generally when you're seeking a loan modification, you have to submit a borrower assistance application as well as participate in the trial plan period, during which you make the trial plan payments to demonstrate your ability to afford the modified mortgage payments. Neither a borrower application nor a trial plan period is required for a COVID-19 owner-occupied loan modification for an FHA loan post-forbearance. Here we are with the hybrid COVID-19 partial claim and loan modification. So if you have some partial claim left, meaning that you haven't exhausted the 30% of the unpaid principal balance statutory maximum value for a partial claim, but that's not enough to take care of the entire foreborn amount, then you can use the remainder of your partial claim to take care of how to defer however much you have remaining from that foreborn amount into the partial claim, and then the rest of the arrears can be recapitalized through the loan modification process. So that means that the remainder of the foreborn amount will be recapitalized into the principal balance, and the loan will be recast at a new interest rate over a new term of years. In this context, keep in mind that the monthly mortgage payment may actually increase. So it's important to identify what the new monthly mortgage payment would be under this option before you agree to it, in order to understand whether or not that's going to be affordable. The term for the modified mortgage, again, is going to be 360 months, less if it's requested by the borrower. And also for the hybrid partial claim and loan modification, all late charges, fees, and penalties must be waived. So to be eligible for the hybrid partial claim loan modification option for an FHA loan, you must have been current or less than 30 days past due as of March 1st, 2020. You must have not exceeded the 30% statutory maximum value of all partial claims for FHA loans. You must indicate an ability to make the modified mortgage payment, and the property must be owner occupied. If your loan is owned by the Department of Veteran Affairs, then as of September 14th, 2020, The VA authorized servicers to offer payment deferrals to borrowers with COVID-19 hardships. So if you have a VA loan, you may be able to obtain a payment deferral. Besides that, standard loss mitigation options apply. So there may be modifications available and things like that. And also there may be a disaster loan modification option through the VA as well. If your loan is owned by the USDA, at the borrower's request, if the borrower can resume making payments, servicers are supposed to extend the loan term by an amount of time at least the length of the forbearance. Again, otherwise standard loss mitigation procedures apply. Borrowers may also be eligible for additional forbearance, so an extended forbearance under pre-COVID rules. However, there are no specific COVID-19 post-forbearance options or procedures, so be aware that there may be increased payments under the existing loan modification rules. All right, so let's talk a little bit more in depth about loan modifications. I know we've talked about it ad nauseum thus far, but we'll talk about it a little bit more just so that we're completely clear. So a loan modification, again, lowers your monthly payment by recasting the loan over a new term of years at a lower interest rate. So there are some sort of real life factors that you're going to have to consider whether or not you're actually eligible for a modification. So whether you're in default or foreclosure, many servicers will not consider a modification application if you're not already fallen behind. Generally, you have to show that there's some sort of hardship. Also, if the property is underwater, as opposed to there being equity in the property, that may affect your eligibility for a modification. Also, sustainability, this is important. So your ability to afford the new payments. If the servicer cannot determine that you would be able to afford whatever the new modified monthly payment is going to be, then the servicer might not be inclined to grant you a modification. Also, whether a modification is going to be available is going to potentially depend on who the investor or guarantor is, especially in the context of these COVID-19 relief options. And so submitting a request for information under the Real Estate Settlement Procedures Act can be a helpful step in determining whether or not your loan is protected by the CARES Act. Keep in mind also that if you are submitting a loan modification application to a servicer, generally it must be submitted at least 5 days before the scheduled foreclosure sale in order to obtain the protections under the Homeowner Bill of Rights. So if you submit your loan modification application at least 5 days before the scheduled foreclosure sale, then the mortgage servicer under the Homeowners Bill of Rights must consider the application before it can move forward with a foreclosure sale. Keep in mind also that you have to submit a complete application in order for this protection to apply. And so you'll want to double check with the servicer beforehand to find out what exactly is required for a complete application. Usually that involves tax returns, documentation of your income, a 4506T form, which grants access to tax information from previous years as well. And so again, checking in with the servicer, identifying what is required to submit a complete application is a good idea. And again, submitting an application for a modification is certainly something that HERA can provide assistance with. So then there is bankruptcy as an option. This bankruptcy can result in long-term harm to your credit. So it is important to seek out a bankruptcy attorney and identify whether or not that's going to be a sensible option for you. Generally, if you if you do obtain a bankruptcy, then through Chapter 7, the debt might be discharged as to you personally, but the lender may still have the ability to have that stay on debt collection lifted and may be able to move forward with foreclosure on the property. So at HARA, we aren't bankruptcy attorneys. We aren't experts in bankruptcy. We would certainly advise you to seek the advice of a bankruptcy attorney in determining whether bankruptcy makes sense. A Chapter 13 bankruptcy as opposed to a Chapter 7. So in a Chapter 13, you're entering into a repayment plan. The bankruptcy court will help to create a payment plan for the debts that are going into the bankruptcy, and that might help to preserve your home as well. Again, whether or not it makes sense for you to file a bankruptcy, it would be a good idea to discuss that with a bankruptcy attorney. Possible advantages of filing bankruptcy. So when you file bankruptcy, there's an automatic stay on debt collection. And so for a period of time, any collection activity, including foreclosure, will be automatically put on pause. So that may be able to buy you some time. However, as I mentioned previously, bankruptcy courts are usually willing to lift that stay in order to allow for mortgage companies to foreclose on the property. Even if, let's say, you do obtain a Chapter 7 bankruptcy and the debt is discharged as to you personally, so you're not personally obligated to pay for the mortgage any longer, that does not take away the lender's power to foreclose on the property to recoup that debt. So that's something to keep in mind. Especially with bankruptcy, it's a very complicated process. So you want to be wary of the folks who are helping you with it. You want to make sure that the attorney that you work with is reputable and ethical, because you don't want to have someone file the paperwork for you and not stick around to help you through the process. So you want to make sure that the professional that you're working with is going to see it through and not just file the paperwork and be done with it. So there are eviction moratoriums in place. Local governments have enacted moratoriums on evictions that typically require the tenant to show that there is a financial hardship related to COVID-19. And some counties also require landlords to offer repayment plans for rent. The statewide eviction moratorium under Judicial Council Emergency Rule 1 expired on September 1st, 2020. So there's no longer a statewide moratorium on evictions in the state of California. However, homeowners who receive forbearances under the CARES Act cannot evict tenants during that time. For a list of eviction moratoriums in California and their status, you can go to the link at the bottom of this slide, and that'll give you more detailed information on the eviction moratoriums. So, as we discussed previously, property taxes can also pose the risk of foreclosure. And so there may be some options for you to dealing with your defaulted property taxes. So if you do fall behind on your property taxes, you may be able to enter into a repayment plan with the county assessor's office. Those repayment plans require a 20% down payment. So depending on how far behind you are, that may or may not be an option. But just generally speaking, when you initiate the repayment plan, a 20% down payment, that being 20% of the total amount of arrears, is required to get that plan started. Some cities and counties also offer reinstatement assistance. So for example, in San Francisco, there's the Help Loan program. In Alameda County, we have Alameda County Housing Secure, as well as funds through the city of Oakland that may be available to homeowners who fall behind on their property taxes. Also, keep in mind that if your property taxes are escrowed, delinquencies can severely impact your mortgage payments. There may be an opportunity for you to challenge a property tax assessment if you are under the impression that the property tax bill was improperly calculated, then there is a procedure for filing an appeal with the assessor's office challenging the assessment. And for future property taxes, so if there's a concern about paying future property taxes, then there may be special exemptions for seniors and disabled veterans that significantly reduce the amount of property taxes that must be paid each year. Also, there is a property tax postponement program for seniors and folks who are blind or disabled may also apply for property tax postponement. Those applications are considered on a first come, first served basis. So if you think you might be eligible, there are other requirements as well, income eligibility maximums and the like. And so if you are concerned that you might not be able to afford your property taxes next year, then it would be important for you to submit your application for property tax postponement as soon as possible, because those applications must be submitted no later than February 10th each year. And as I mentioned, they are on a first come, first served basis. So it's important to get them in as soon as possible. Something that you should keep in mind when you're having trouble affording your house payment, if your mortgage falls into default, you may come across a foreclosure rescue scam. And so there are some things to look out for, some red flags that we want you to look out for because we don't want you to get scammed. So often a foreclosure rescue scammer will require an upfront payment to help you to seek out a loan modification or some other foreclosure prevention option. These services should be free. It is unlawful to charge upfront for these homeowner counseling services. And there are also organizations like CARE that offer them completely free and won't ask you for payment when it's all said and done. So, you know, that's definitely a better option. Also, if someone comes to you and tells you that they will make your mortgage payment for you, that might be problematic. That would certainly be a red flag. Also, if you receive any documents that don't look genuine, like a notice of sale, for example, that doesn't look legitimate, that also might be a red flag that you're being scammed. Folks coming to your door, making promises that they can save your house, that they can for sure succeed in obtaining a modification or whatever workout option they're promising. Making broad sweeping promises like that is not a good sign. Any ethical professional would not overpromise at the outset like that. They would assess what your realistic options are and then give you that advice then. Also, as I mentioned, any upfront fees in this context, if you're being charged upfront for housing counseling services or you know, loan modification assistance, any of that, that's unlawful. You should not be charged upfront for those services. Especially those broad sweeping promises I talked about before any documentation has been looked at. Again, a responsible professional would not make promises before they've reviewed your documents and have a realistic sense of what your options might be. Also, when you are being pressured to sign documents, if the person whom you're dealing with is insisting that you sign before you review them with an advisor or another attorney or anything like that, that's not a good sign. Any ethical professional would give you the time to reflect on whatever agreement they want you to sign, would give you an opportunity to get a second opinion about it. And so if you're being pressured to sign documents, that's a sign that you might be getting scammed and you would not want to continue. If you do get caught in a foreclosure rescue scam, report it to the police, report it to the Attorney General, the Consumer Financial Protection Bureau. Stop communicating with the scammer and call HERA or another HUD certified mortgage counselor so that we can set you on the right track. All right, so here we are. rights of survivors. So if the borrower or homeowner passes away, then the surviving spouse or children might want to keep the property. So there are some common issues that come up in this context. So first of all, the surviving spouse or children might not be able to afford the mortgage payments due to the decrease in income after the death of the homeowner. They might not have information about the loan. The servicer might not provide important information or accept the payments. And they also might not allow the servicer might not allow the successor, meaning the surviving spouse of the child, to apply for a loan modification or assume the loan. So the Garn-St. Germain Act provides an important protection. So if a relative inherits and occupies the residence, then the Garn-St. Germain Act prohibits the lender from enforcing the due on sale clause. So for the vast majority of mortgage loans, there is a due on sale clause, which means that when the property changes hand, the mortgage is due immediately upfront at the time of the sale. The Garn-St. Germain Act prohibits the lender from enforcing the due on sale clause when a relative inherits and occupies the residence. So that's an important protection. Also, the surviving spouse or child is protected under RESPA, the Real Estate Settlement Procedures Act, and is entitled to continue making the monthly mortgage payments. The successor can also apply for a forbearance or modify the loan by showing that they are indeed a successor in interest, and there are a variety of ways to demonstrate that you are in fact a successor in interest. For example, a deed showing that the property was held in joint tenancy with the right of survivorship, meaning that the tenants who remain after the homeowner passes away inherit the property automatically by virtue of the right of survivorship. Also, a trust may also be evidence that you are a successor in interest, a will, or any probate court orders ordering the property to go to the successor. Okay, and so this is the last slide here. We've arrived at the end of the presentation. Thank you everyone for participating. I just briefly wanted to mention again that HERA offers free legal services related to debt, credit, and home ownership generally. We help folks with debt collection, whether it's a student loan, an auto loan, medical debt, homeowners association fees. Again, we help folks with credit reporting if you're concerned that you've had identity theft or that there are errors on your credit report. We also help folks generally with foreclosure prevention and other mortgage servicing issues, of course. We offer special services for veterans and service members, and we also offer estate planning. That is offered on a sliding scale. So that's the one service that there is a sliding scale fee for. But so we offer estate planning, and that's just generally simple wills, trusts, healthcare directives, and powers of attorney. So I'm going to stop sharing now. And as we...
I was just going to chime in, Daniel, and say thank you. What a wealth of information. And no one is expecting any of our participants to know everything. And I just wanted to remind everyone who participated this evening will get this deck. And I think it's going to be a very valuable resource to refer to. I'm hoping that you are well connected to family, friends, and you may even see or know individuals that are going through this hardship. So please share the information. And also want to remind everyone, as a HUD counseling agency, we too can support with foreclosure mitigation. And when things get too hairy, we lean on our friends like HERA. So as they say, it's not what you know, it's who you know. So we have a great partnership. So we do have a few minutes. So if you have some direct questions for Daniel, he's happy to answer. And if we do run over in time, you can put your questions in the chat and then we will get those answers and reply to everyone. But for the time being, if you have a question, let me know. You can unmute yourself and Daniel is available to answer. So are there any questions out there?
I have one. Hello, everyone. Can you hear me?
Yes.
Okay, great.
Well,
The slides you show how your presentation was wonderful. Bravo. It was really good. Are those slides available? Or Nikki, maybe you've already provided them for us, but I can't find them in the email.
Yes. I just mentioned everyone that attended tonight will get them. You'll get them sometime tomorrow before end of day.
Okay, thank you.
Great.
You're
Great
welcome.
class. It was
thank you,
great.
Nikki. Thank you, Piccola.
You're welcome.
Any other questions for Daniel? Well, what we can do for those that would like to end the course, you're welcome to drop off, but those that may have some questions, you're welcome to stay on. I'm going to go ahead and end the recording and just let everyone